let's get onto the phone because Martin Kwibu has joined us, private legal practitioner. Martin, good morning.
Hi. Good morning, Winston.
And I see you've been celebrating recently.
It's crazy.
You've been wearing white
all of us.
You have been wearing white all the time after the elections.
Yes, I was looking forward to a resounding victory, and it's happened. So we sent a clear message to Kufuor that he doesn't have capacity to govern. He's just not up to scratch. So now I'm sure he can go and rest and know that yes, all the touting they did, that he had been prepared for 4 decades. That this is a man who had been prepared for 4 decades to become president, and he performed abysmally. So I'm wondering how he would have performed if he had been prepared for only 10 years or 5 years.
Okay, Martin, let's get back to
Martin, congrats, you did well. You did well.
Congrats.
Sorry, Mr. Kwibu, are you a member of the NDC?
Oh no, I'm not. I only gave them support. Tell me every 8 years I change.
Okay.
Yes, I change. I wish we would even change them every 4 years because our systems are weak. So the better form of accountability is to do post-regime. When the government is no longer in office, then the public servants and the civil servants can bring out more documents, and they will be able to access and see all the rot. Like now that we've voted out the MPP, you're going to see how a lot of rot will be unraveled. A lot. So, I mean, ideally, we should be doing it every 4 years rather than these 8 years then.
Okay.
Because people were worried that he was being more Catholic than the Pope and celebrating more than the people who went to the election themselves.
Oh no, but he did work. He did work, and he got a bashing for it. Martin, didn't you?
Yes, I got a lot of bashing, but can you imagine how life would have been for me if the entity had won? So, to that extent, once I'd shown that Kufuor is not good, and Baumia is worse than Kufuor, I had to go all out.
Okay, so let's get to the issue. And over the last few days, there's been press conferences and suits here and there. The NPP says they won the outstanding 12 constituencies. The NDC has gone to court because they say post a declaration, the only thing you can do is to go to court. But the NPP is insisting these were not done properly, and so they support the Recollation. Martin, what's the position of the law?
Okay, so listen, our starting point is the CI 127.
Okay.
Now, and also the EC's own practice. So let's say there are conventions and practices over the years. Now, after you've gone through regulation 39, 43, etc., you don't see any provision for recollation after a declaration.
Okay.
So that's the main thing. When a candidate is been declared as having duly won the elections, you don't see any provision that gives the EC the mandate to do another collation or call it recollation. And this ties in with the EC's own letter, in 2020, in respect of the teaching and staff matter. There was a letter the EC wrote. I've been looking for the beginning of the letter. It's in reference or in response to the NDC's request. And the EC was clear, very clear in paragraph 13, that after a declaration, you cannot do any collation. That's what we call the recollation. So, in the circumstances, the CI 127 is what was used for the 2020 election. And then, it's the same CI that we are using for this election. So, it's difficult to understand how the EC can do a U-turn to now support and actually superintend over a recollation. So that's where the real issue is. I'm looking for right time my CI, because let's look at the CI 127. the regulations, and it's sometimes good to read out portions for emphasis. But this is the gist of the matter. But as we wait to read through,
Yeah, Martin, if you could kindly speak up a bit for us, we can hardly hear you.
We would also separate those constituencies where they have not finished the collation from the ones that they duly collated and declared some candidates winners. My understanding is that some of the constituencies, they did not finish the collation. So I understand in Sawam, Adoju is one of those. So if that is true, then for those that collation has not been done, we should allow the law to take its course. That's to say, we should go ahead and have the collation done. But for those that collation was done and certain candidates declared winners, that is it. End of the road. Like James said, it is finished. So you can't go and do any recollation.
Maybe the 30th December 2024 statement from the Electoral Commission signed by Deputy Chair Operations Samuel Tete will put it in proper perspective. It says the Electoral Commission wishes to inform the general public that the recollation is the word used of presidential and parliamentary election results, which was ongoing at the Tesano Police Depot for constituencies whose collation did not, and this is the key point I want to point out, did not follow the legal process as enshrined in CI 127, as well as constituencies where collation on election day could not be completed. So the criteria for the recollation is based on two basic things. First, in areas where they didn't follow the legal processes as enshrined in CI 127, as well as in constituencies where collation on election day could not be completed. You say that if the EC takes the view that a certain collation and subsequent declaration was not in tandem with the act, with the regulation, they should still allow it pass.
Because bottom line, the EC's own officers have declared certain candidates winners. So if you declare somebody a winner, then that is the end of the matter. Let that case then go to court. Because you see, Winston and Raymond, don't forget, mistakes happen in elections. And it's also very clear that you cannot use administrative lapses to nullify somebody's votes. Remember, that is the gist of the 2012 election petition. Ekufuado, Obechedi Lamte, etc. versus John Mahama. So you see that when it came to the crux of the matter, which was that some presiding officers did not sign, etc., the Supreme Court held by 5-4 that you can't use the administrative lapses to nullify the sovereign will of the people. So the same principle, or even if it's not that one that will apply, you let it go to the court, and then the court will decide. Because then, if we don't do that, then it means that very soon we'll constitute the EC into a court of law. So everything, they will resolve it. My bottom line is that once a certain candidate has been declared a winner, if you go ahead and declare somebody a winner under Regulation 43, that is the end of the matter. So if you look at 43 D, publicly declare as elected in the parliamentary election the candidate who had the highest votes. You see, that's the answer. The candidate who had the highest votes. So when it goes to court, it will then be for the judge to determine whether in the circumstances of each case, the fact that the one who did the declaration is not authorized is enough to cancel the victory or the win of the person who is the declared winner. Then we'll take it from there. So the EC has no locus. Like I said, looking through the CI, you don't find any other provision that after the declaration, you can go and then say you are recollating. And also the EC's own letter is very clear. So I heard things like what Raymond you've read, that the law was not followed and the rest. No. EC doesn't have a mandate to determine that because certain laws do not appear to have been followed, then the declaration is wrong. Such determinations are made by the court. You remember, that's why we have Article 99. The High Court will determine whether a person has been validly elected. So if the EC is not doing such things, what will the High Court do? If we borrow Baumia's words. If the EC is now in the process or is in the practice of doing declarations like this, then what work will the High Court do? For the avoidance of that, let's go to Article 99. They will tell you that the High Court. Okay. Yes, so it's here 99. The High Court shall have jurisdiction to hear and determine any question, whether a person has been validly elected as a member of Parliament, and then you go on to the rest.
That is without dispute. Forgive me, but I think the clarity that the Electoral Commission, and for further and better particulars, I'm taking you to the 10th December statement of the AC, when it gave an update on the collation of results in specifically Ablekuma North. Let me put it in proper perspective. The EC says the Commission, however, believes that this collation should be done in accordance with the legal requirements enshrined in CI 127, which requires every political party to present 2 agents to the collation center and directs that collation be done by the returning officer and any other officer designated by the Electoral Commission. These people designated by the Commission itself. Contrary to legal requirements, what is currently transpiring is that political party supporters continue to besiege some collation centers, threaten and physically abuse our staff and destroy property. Additionally, these supporters order our staff under duress to declare results which are not reflected on their pink sheets. What the Electoral Commission is saying is that the people who are mandated to do the work, they did not do it because they were saying the facts on the pink sheet. They were being forced. It's almost like the declaration was procured. Can the people whose direction they are representing, as in the commission itself, not correct this before a court comes in?
Not at all. Not at all, Winston. Raymond. Raymond, let's go back. The same logic. In 2012, the presiding officers who didn't sign also didn't sign for one reason or another. So now, if we get into this business of trying to say for certain reasons we do recount the recollation and for other ones we'll let it go to court, it's not healthy.
But Martin, in a case where you have results, okay, and the EC says the proper procedure wasn't followed, we still have the pink sheets. So let us go through the pink sheets that we have, which all of you have signed to. Why should that be a difficulty?
No, listen, let's go back. Don't forget, this is an EC whose credibility has been going down the slope, right, over the decades. It's been declining. The latest Afrobarometer, you see that it's been declining. Yep. So the point I'm making is that on what basis would we believe the EC rather than the NDC or the MPP? So that's why there's an impartial and independent arbiter, at least on paper. That's how the court is supposed to be. So let's go try it there. Because this is an EC that you cannot trust. I can't trust the EC. All right? So let it go to the court. Yeah. If the court goes through and finds that the right procedure wasn't gone through and it is so grave that it will nullify everything that has been done, the court will so hold. Then we would know our way clear. But the EC cannot be allowed to now jump in because these things about duress, etc., they have to be tested, cross-examination, etc., in a court of law, openly for everybody to see. Well. Because I have seen NDC disputing those claims. Why is it that so far, you see, Abu-Dinapo seats, people have made a case that when the EC was talking about seats that are outstanding, blah, 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 they didn't mention Abu-Dinapo seat. the person who declared Abu Jinapo winner, was that the returning officer? Then they say the returning officer had fallen ill and some different reasons. So to avoid these things, and there's another, there's another constituency, the same thing. That one, the EC didn't talk about that. And so commentators are easily seeing the bias that the EC is on the side of the MPC. That's why I said, let's go to the impartial arbiter, or the person that is said to be impartial, at least according to the Constitution. Then let's see what the courts will say.
Now, generally, there is concern that security for collation has been very, and that the need to protect these collation centers and the officers who are supposed to do the declaration has also been poorly done. Is there protection in the law for, say, returning officers? I know that you cannot attack them, but is there protection for them? Was it the responsibility of the EC or the security agencies to provide this protection for these people?
It's the responsibility of the police, the Election Security Task Force.
Okay.
And also the EC has an input. So the EC, knowing the conditions under which the returning officers, etc., work, can make an input that, okay, within the security should be X, should be Y, should be Z. So, though, ultimately, it is the responsibility of the Election Security Task Force, but the EC can make an input as to how it should be done, because those are agents, and some of them too are employees of the EC. That's how I see it. And under the law protects all of us. All of us, okay? So, just as it's not allowed for Winston generally without any provocation to slap you, Raymond, it extends to the returning officers, residing officers, etc. So generally under the law, if you assault somebody, or you hit somebody, it's an assault. That's the criminal side. Yeah? And then in civil law, it's a battery, etc. So in civil law, these persons can sue for compensation. Right? So there is a general protection for all citizens. Yeah.
In the case of Ablikmadot, where we heard this morning that some ballot boxes have been burnt, and we know that there is dispute over the declaration there too, what will be the eventual outcome if there is the need to go back to these ballot boxes, open them, and not do recollation, but a recount of the ballot in the area?
Impossible.
Yeah, so now that the ballot gone, well, the EC has a rule, so many rules may come into play. But my understanding was that once they had the pin sheet, the 2/3 rule, you can use 2/3 of the pin sheet to do the collation, and so that should help resolve the matter.
So you say 2/3 rule. Which law is that?
That's I haven't seen it in the CI, but that
yes,
is
me
what
too. I don't know if
now.
it's in the 127. So I'm asking, which law mandates this 2/3 rule?
Yeah, so that's why I haven't seen it on the CI, but we told that is one of the rules that the EC uses. So, and it appears to be acceptable to the parties. Apparently, this is not the first time they are invoking it. I'm yet to hear any political party rise against it. So it appears that is an acceptable rule to them. Because somehow we must resolve these issues.
Yes.
You cannot say that the absence of that rule in the CI means that then there should be no coalition at all. Because we must get an MP. So the court will decide. So you see, when all these matters go to the court will decide whether to uphold that rule of practice or to nullify everything and say, okay, they should go again and re-vote.
All right, Martin. Thank you very, very much for joining us this morning. Martin Kwebu is a private legal practitioner.